Hello, and welcome to Counseling Ethics, Lecture 14. My name is Dr. Amber Hughes. In this lecture, I want to talk about exceptions to confidentiality. So we've talked about what confidentiality is. We've talked about what privilege is. Now I want to talk about exceptions to confidentiality. We talked about exceptions to privilege during the privilege lecture. Remember, privilege is specific to like court systems, and it's a legal requirement, whereas confidentiality is an ethical requirement. Okay, so I wanted to talk about exceptions to confidentiality in a different lecture because it can be a pretty big issue. There are times when we ethically must break confidentiality. So first, as with privilege, a client can waive confidentiality. This might be in instances of going to court where privilege and ethics go hand in hand. But it also might be when a client wants to release information to someone, maybe a medical professional, like if they're seeing a doctor and they want to share their notes to help provide better care, which is super appropriate. And they also might want to share information with a family member. Counselors also can break confidentiality when we have to share information with subordinates or fellow professionals. So like if you have someone who takes care of the clerical part of your office or of your agency, you can share information with them in order to provide the best possible services to the client. So if they're handling information, if they're handling paperwork, if they're helping with documentation, it's appropriate as long as they have appropriate training. It's appropriate to break confidentiality in those cases. Counselors may also break confidentiality to consult with colleagues or experts. If you need to talk to someone who knows more about a certain issue than you do, it's appropriate to break confidentiality then. Now, likely, and in all these cases, you're only going to share as much information as you need to. So you're not going to be telling names or anything like that. If you're doing a consultation, you're just going to be sharing clinical information with the experts. Counselors may share information when conducting or when they're under supervision. And finally, you can break confidentiality when working with coordinated client care. So if you're working with a team of like case managers and maybe a psychologist or a psychiatrist and you do team meetings, it's appropriate because the purpose is to provide the best care possible for your client. It's appropriate to break confidentiality then. So for example, during your field work, you're going to be sharing information with your supervisors and your classmates, and this is an appropriate break of confidentiality. That's part of the training process. However, you would document it with your clients, so you want to make sure your clients know that you are going to be sharing information with your supervisors during supervision. And you would talk about this during informed consent. Now, probably the most concerning time of breaking confidentiality comes with protecting client safety. So there are three types of duties counselors are required to follow: the duty to report, the duty to warn, the duty to protect, and the duty to report. Counselors must take action when they suspect abuse or neglect of children or other persons presumed to have limited ability to care for themselves. We have a legal and an ethical requirement because legally we are considered mandated reporters. So we have a legal and ethical requirement to report child abuse or neglect, or like elder abuse or neglect, any of those instances when people are being cared for by others. Counselors must take action to protect clients who pose a danger to themselves, so in cases of suspected suicide. Counselors must take action when a client poses a danger to others. So if you are given information or you suspect that a client may harm other people, you can break confidentiality then. And finally, counselors we have to determine, so it's not necessarily a requirement, but we must determine whether to breach confidentiality when a client has a fatal communicable disease and their behavior is putting others at risk. So for example, if a client has HIV and they are engaging in sexual behavior without informing their partners, then we can make a decision about whether to break confidentiality then. Because these exceptions require that you make a deliberate decision to breach a client's confidentiality, there must be a compelling justification to do so. So for example, in cases of suicide, you would do a suicide assessment, okay? And you would determine level of risk. Same with all of these other instances. You would do a harm assessment if you're concerned that someone may harm someone else. Because we are breaking confidentiality in these instances, we are entering into an ethical dilemma where we have two parts of our code in conflict with one another. A client's right to confidentiality with a client's or other people's right to safety. It's never an easy decision to do this, and you have to consider all aspects of the situation. Anytime you are making this decision, you should go through all of the steps of the ethical decision-making model we discussed earlier, and we will refer to that model again. But you want to make sure you get through all those steps, that you provide documentation along the way, and you don't take this decision lightly because it's not a light decision to make.